morning, Joe. Good morning, gentlemen. Nice to see everybody's faces. You don't see so many faces these days, either because you're not actually in the office or wandering around the streets, or they're behind masks. So nice to see some lots of familiar but unmasked faces. Lots of thanks going around at the moment, which isn't to derogate from the sincerity behind any of those thanks. Can I kick off by thanking Mark, the committee, and indeed the society for allowing myself and Mark and now young Jack to be involved with the committee, with the society, and to come along and yeah, okay. So we give you some information about what's going on in the legal world, but we also take away some very good insights into what makes you guys tick, what you're seeing, and how things work technically. It's a bit hard to try and persuade a member that there's something wrong with a facade if you don't know what a facade is. So we're indebted to you guys as well for that. So kicking right along, we have, of course, every year under the Constitution, all the committee positions are declared vacant, and there's an election to replace the committee, assuming that there are more people who put their hand up for the committee positions than there are actually committee positions. It's very, very rare in my involvement with the society that there has actually been a need for an election. And this year is very similar to previous years insofar as the people the numbers that have been nominated and proposed and seconded equals the number of committee positions. So firstly, I'll formally declare all the committee positions vacant, and then I will declare the committee positions to have been filled by the following persons in no particular order: past President Dale Kennedy, Ordinary Member John Cunliffe, Ordinary Member Steve Nackler, Ordinary Member Chris Dice, Secretary David Roberts, Treasurer Ed Pinder, Vice President Graham Thorpe, and President for another year going around Mark Williamson. So congratulations to those gentlemen, and thanks for putting your hands up to fill these positions, especially those who are going around again. So well done, gentlemen. Can I then finish with some thanks for the work of, thanks and recognition for the work of the committee over the last year, and I'd especially commend the work that's been done on the website, social media, Graham's work organising the Newcastle chapter, and the work of the committee getting on that strata inspection team. That's I think that's going to be very important in the years to come in terms of a source of work for members. So well done there. And last and certainly not least, thank you to Jo for all the work that she does, including the work coordinating us at Bartier Perry to come along to meetings and reminding us when they're on, etc. So thank you, Jo, for that. And I'll flick back to
David,
to our host.
I just sent you a chat.
Did you get the chat? Yep.
Yes, I did get the chat, and Graham, of course, is the chair of Graham Thorpe, of course, is the chair of the Hunter chapter. So declare that position filled as well.
Thank you.
Good work. Good work. Well, that was relatively painless. We've got John Cunliffe that's come into the committee. So welcome, John. We'll look forward to working with you on the exec committee and getting your input into how we work. And the other guys that are going around again. Look forward to the year that is coming. Yes, how far this pandemic will stretch into next year, we will see, and what challenges it will bring. But yeah, I'm sure that we'll take all these challenges on and work our way through it. as David just said, I think the biggest thing for the society at the moment is the Strata Inspections Panel, and getting that panel set up and established, and members' involvement in doing those inspections for the strata defects. So, yeah, thanks David for again chairing the election, and yeah, running it through smoothly as ever. So we've got an update from Bartier Perry, legal update.
Okay, so I'm back again.
You're back again. Welcome.
Back again. Yeah, back for more. Okay, so this morning I've got a short summary on 3 cases that caught my eye and hopefully have some relevance for you guys. The first one is one Capello and Hammond and Simmons, New South Wales. The issues in this one were twofold that I want to briefly talk about this morning. One is the question of a builder being able to claim a quantum merit, so the reasonable cost of work, not what they're entitled to under the contract, and the second about delay damages. As we know, probably more building contracts than less delayed, the work's delayed, and the question of extensions of time and delay damages come up quite regularly. So I think that's quite pertinent. So firstly, in terms of the quantum merit or reasonable remuneration for the work done, this was a cost plus contract, and it was terminated by the builder because the owners refused to pay. It was found, of course, as with a lot of these things, I'm sure you've all seen cost plus contracts. The common concern is that the costs blow out. The owners say, oh, well, we were told there was an estimate of something like 60% of what ended up being charged, and I've been overcharged and I'm not paying, etc., etc. One of the classic dangers of a cost plus contract. So same thing happened here. Clients refused to pay, builder terminated the contract, and then the builder went back and said, okay, well, I need to be paid reasonable remuneration for the work that I have done that I haven't been paid for. The issue here is a High Court case called Mann and Patterson Constructions, which basically said, well, whatever your reasonable remuneration is, it can't be more than what was calculated in accordance with the contract. And here, the builder, instead of calculating what he might be entitled to according to the rates in the contract, have gone and got a quantity surveyor to make an assessment of what what reasonable remuneration would have been for the whole of the work. He then deducted what he'd been paid and said he was entitled to the difference. Well, the court said, sorry, can't do that. You have to assess what you've lost on the basis of the rates in the contract. In other words, there's no room to elect to claim a reasonable remuneration unconstrained by the contract between the parties. So if you guys are assisting a builder, or indeed, I guess, owners in terms of what might be owed under a cost plus contract that hasn't been paid, it's not just a case of working out reasonable remuneration. You've got to look at what the contract rates were. Secondly, delay. So again, like where there's extra cost, usually there's delay. This one, the contract, absent any extensions, had to be completed by the 5th of March in a particular year. It wasn't completed until October. And so 7 months late, and the builder hadn't sought any extensions. So the owners claimed delay damages. Thing was that in the contract, delay damages were specified as $1 a day. I'm sure you guys are quite familiar. Most building contracts, at least where the builder holds sway, will have a nominal amount for liquidated damages. So the question was, were the owners limited to their $1 a day, or could they claim more? Well, the court held that because it was a nominal amount, that clashed with the statutory warranty that says that the work will be completed within the time stipulated in the contract. In the absence of that, there'll be an entitlement to damages. And what the court said was that a provision of a contract which limits a party to claiming nominal damages for a breach of that warranty has the effect of restricting the rights of the owner in respect of the warranty, and it is therefore void under section 18G. So if you see nominal damages clauses or nominal amounts in a liquidated damages clause, it's probably void. Unfortunately for the owners, that ultimately didn't help them, because if you have a right to damages and it's not going to be assessed in accordance with your liquidated damages clause, then you've got to prove what your damages were. These owners said, oh, well, we reckon our house lost about $370,000 value between the date that the contract should have been completed and the date it was completed, because this house was close to the WestConnex works, and said that the WestConnex works diminished the value. Well, the judge said, no, that's all too remote. It's too much speculation. So I won't allow you that. And they said, in the alternative, well, how about 30 grand? That sounds about right. Well, that's no evidentiary basis to get damages for delay. So ultimately the judge said, well, I'm sorry, the only thing I've got to go on is your $1 a day, so I'll award you $152 for your 7 months delay. So lots of salutary lessons in Capello and Hammond and Simmons. And I should mention that Steve Nackler was involved in that. There was some defect issues there. I won't go into those, but by all accounts, from what I can see in the judgment, Steve did a good job there in terms of containing the amount that was awarded for defects. The second one I want to talk about is a matter of Cohen and Zanzul trading as Unique Building Group. The reference, the reason that I think this one's maybe of some interest is about the right of a builder to go back and rectify defects. And what had happened here was that the owner said to the builder, I want you to come back and rectify these defects. The builder said, well, I'm more than happy to come back and fix the items. You say it effective, but you'll need to address the long overdue payments to which I'm entitled as well. Needless to say, the owner didn't pay any money and the builder didn't come back and rectify the defects. Once they got to court, the builder said, well, the owner failed to mitigate their loss because they didn't give me the opportunity to come back and fix the defects. And the court held, well, in fact, if the builder had any entitlement to come back and rectify, he didn't exercise it because he wanted an acknowledgement that he'd be paid. He said he wouldn't return to the site until he'd received that acknowledgement, and whilst that may be reasonable and understandable, nonetheless, he was not denied the opportunity to come and fix the defects. So again, if you're acting for or assisting an owner or a builder, bear that in mind if there's talk about the need for rectification. But it said that the builder's not coming back until he, she, or it gets paid. The last matter is a matter of Kuhn, and Joe, I'll send you through the references for these so they can go in the notes somewhere. Kuhn and Masterton Homes. This one is relevant because it got to NCAT, and on the 4th or 5th day of the hearing at NCAT, Phil Bambajotti, barrister, with whom a lot of you will be familiar, got up and said, well, I'm very pleased to say that the matter's settled. We've reached agreement, and yes, it needs to be resolved into the terms of a formal deed, but we're out of here and you don't have to make a decision. As sometimes happens, there were things to be done under the settlement, including the formulation of a deed. They went backwards and forwards between lawyers, and ultimately the settlement on the view of the owners, the Coons, fell apart, and they were no longer bound, and they wanted to go back to NCAT. Masterton said, no, there's a binding agreement. Even though we didn't actually get to execute a deed, nonetheless, the principal terms were there, and you can't go back. Well, the judge held that, unfortunately, that wasn't right. Couple of significant things. One was that there are two homeowners who were named in the contract, but only one of them was the applicant in the NCAT proceedings. So that meant that any agreement that had been reached could only have been between one of the owners. The other owner still had rights. So lesson number one, make sure that all the parties to the contract are bound in any settlement, any agreement, whether it's before or after you get to NCAT. Secondly, and importantly, the payment that was to be made by the owners to Masterton was to be made 28 days after execution of the deed. Without a deed being executed, there's no trigger for the payment to be made. So that indicated that the settlement wasn't immediately binding as well. And lastly, it was said that the deed contained terms that were inconsistent with the reasons and the assertion that the settlement was immediately binding. So no cigar for Masterton Homes there, unfortunately. But it just highlights that whether you're in a conclave or in part of a mediation outside a conclave or outside NCAT, or even if you reach a settlement in NCAT, make sure that everything's written down and signed off before you go your separate ways. So they're the three little legal gems I wanted to throw at you guys this morning. Has anybody got any questions or anything in general they want to ask?
Yeah, David, just on the second one.
Yep.
So what would you say the moral of that story is?
The moral of that story is that if you are a builder and there is defective work, then absent reaching some agreement with the client to make a payment on something happening and being sure that that's going to happen, you need to go back and rectify the work, even though you haven't been paid.
Yeah, regardless.
Regardless.
Okay, thanks, mate.
Okay, well, if that's that, I'll leave you with this. Mark highlighted in his review of 2020 just what an impact coronavirus and the pandemic has had on all of our businesses and the way we work and so on. And so I think it's probably fair to say, and I'm in the city today, but I've certainly been working from home most of the time, as I know have Mark and Jack. And that means we're spending more time at home. We're not getting out. Maybe we're starting to get a little bit bored and looking for things to do. Well, I came across a note from someone who'd found things to do apparently during the coronavirus, and I'll just share my screen here so that you can see that. So I think it's one, maybe don't try this at home. So thank you, gentlemen, and enjoy the rest of the morning.